Item number 1, criminal petition 16 of 2024.
Criminal petition dismissed.
Item number 2, criminal petition 15 of 2024.
Petition allowed. Bail condition modified. Now the petitioner has to submit bail bond for a sum of rupees 2 lakhs with 2 sureties of like amount.
Grateful, my lords, grateful.
Obliged, my lords.
Yes, mention.
Yes.
Lordship, here we are state of Assam, we filed an appeal matter against the execution order matter. That execution proceeding is pending, that is fixed on 13. May I pray for take up the matter on 8th of August, my lord.
When?
8th of August, my
8.
8.
Volume.
May I please, your lordship?
Yes.
With the consent from the other side, I beg to mention item number 6. Senior counsel Mr. G. N. Saivara is out of station.
Miss
K. Bhattacharya.
Learned Counsel appearing on behalf of Mr. Z. and Sayola, Learned Counsel for the appellant. With consent from the other side, press for listing the matter on
20th of August, lordship.
28th of August
2020.
2028 on account of no, on the ground that Mr. Sayola is out of station. Fair is accordingly allowed. Recessal is the matter on 28th.
Obliged. Please, your lordship, I beg to mention listing the matter I, Lord C. Stay vacation.
When?
14th August.
When?
14th.
14th.
I beg to mention item number 11 and 12. We have consent of other side. 2 weeks time may be given for
11 and 12.
11 and 12.
Your good name?
K. Gupta. K. Gupta.
K. Gupta. Mr. K. Gupta, Learned Counsel for the appellant.
Appellant, sir.
With consent from the other parties, other side, press for listing the matter on
After 2 weeks.
after 2 weeks. Okay. Fair, Lord.
Lordship, I beg to mention item number 9. After expiry of Advocate B.R. Gogoi, sir, the clients informed that they will be engaging some other advocate.
Hmm.
So maybe adjourn this matter.
You were appearing for
Sir, appellant Manoranjan Singh.
appellant.
Yes,
Your good name?
M. Ahmed, sir. On behalf
Mr.
of
M.
SC
Ahmed, Learned Counsel. For the appellant with consent from the other side. Any objection? No. Press for listing the matter after
3 weeks.
3 weeks. You are not the opposite party here. You inform the other side? No. Did you inform the other side? No. You have to inform, you have to obtain consent, only then we will allow.
Sir, my seniors instruct that they mention the matters.
No, you inform the other party. We'll call the matter.
Always.
Please, my lordship. My lordship, I beg to mention for listing of an RFA that has been pending since long. So can we?
When to be listed?
Your lordship,
When?
it was 23,
No. When do you want?
the day after tomorrow, 8.
8.
Thursday,
So many cases were on
Friday.
14th,
Friday,
on 14th or 12th, Monday.
Monday.
Well, is it a hearing with it?
Hearing.
Then 13th. 13th.
13 will be a little difficulty. Because it will be, our eldest council will be out of station. Can it be on Monday or Friday?
Tuesday or Thursday hearing it.
Next week?
28. 28.
May I please your lordship? Lordship, I'm praying for listing of two RSA for withdrawal, lordship.
When?
Any date this week, lordship?
Withdrawal for tomorrow.
Obliged.
For withdrawal?
Withdrawal.
Next, I have filed an IA Milan in pending case Milan for to vacate the stay order Milan. And it is filed Milan on 31st of Milan, July. So my prayer it may be listed on 12th of
12.
12th.
May I please your lordship?
কবে ভলিউম তো আৰু নাবাহিনী Yes,
So I would to mention item number C, lordship.
item number
C. Can it be taken up at 2, lordship?
6,
C.
3,
C.
2 p.m.
Hi.
Okay, all right.
Obliged, lordship.
May it please the lordship.
Yes,
So I'm praying for listing of two matters, lordship. One, CRPI filed yesterday, that may come up on Friday next, lordship. On
Friday?
Yes, lordship.
কবে possible? Okay,
And lordship, another, I filed one RFA with condonation petition. It is, the execution petition is pending. So matter will come up on, taken up on 8th, lordship.
Okay, 12. Monday, 12.
12th.
8 already, lot of matters have been
Because
fixed.
It is on fixed on 8th there, lordship, the court below.
On?
On 8th, lordship. So,
Okay, we'll try. We'll try.
obliged, lordship.
Yes.
Your lordship. I beg to mention item, two item for listing. One is CRP, which is will be listed for motion.
Yes,
May it be listed on 9th of this August.
9th of August. কবে
Next week.
possible?
Next week. Next week.
On Monday then?
One on 12, one on 14.
Obliged.
May I please your lordship? I am praying for listing of one MSc matter on Friday.
Friday? Friday not possible. Next Tuesday? Tuesday.
Tuesday, 13th.
May I please lordship? See, with the concept from the other side, I beg to mention item number 2, lordship. Lordship,
Item number 2.
Item number 2. Should the engaged contracting council could not be present before this on court today due to artificial clock situation of yesterday. So matter may be adjourned for today and maybe fixed any other day.
As agreed by learned advocates of both the parties, recess will list the matter on when?
Immediate.
Lordship on 20, 20,
20.
20 Tuesday.
Yeah.
Okay.
Yes.
Item for admission, item number 1.
May I please?
Yes.
This is a transfer petition, my lord. It is proceeding from the family court Guwahati to Karimganj. Wife is.
Guwahati to
Karimganj, ma'am.
Karimganj.
Wife is from Karimganj. The husband also is from Karimganj. But this proceeding has been filed by the husband at Guwahati. My lord, this wife has, my lord, 2.5 years of old children also. It is very inconvenient for her to come from Karimganj to Guwahati to attend this proceeding, my lord. That is, this application has been filed. And it is admitted by the respondent that husband is living at Dubai. And he has filed this case here at Guwahati. Secondly, my lord, it is also admitted it is very difficult to, it is very inconvenient for also himself, also the husband, from Guwahati to Karimganj. It is admitted also. Then also he has filed this case at Guwahati. This is my friend. Already notice has been issued and proceeding has been stayed.
Yes, Mr. Decker.
Yes, my lord. In this case, my lord, today is the date fixed for reconsideration of further the interim stay of 10, my lord. It is for reconsideration fixed, my lord. Well, if my learned friends complete his argument, I will start my argument. If he's finished, then I will start my argument. I have some points for arguing this case. First of all, my lord, the instant case, my lord, is the file, to transfer of the case from Guwahati Family Court to the Karimganj, my lord. My lord, in this case, my lord, I'm having residence at Guwahati. I'm temporary residence, and I worked at a
No, if you were residing at Dubai,
No, my lord. I work there, but my temporary residence at Guwahati and my Karimganj is my home place, my lord. But Guwahati, even they admitted in their application, yes, I am in temporary state house at Guwahati, my lord. My another address is at Guwahati, my lord. And why, my lord? Guwahati is the convenient place. I filed this same matter, my lord. This is a case filed, my lord, that I want to get back my wife and my daughter for restitution of under conjugal right. This provision I file in this case, not that for separation to leave my wife and daughter, my lord. And what happened, my lord? In this case, when I lost this case for restitution conjugal right, thereafter, my lord, when the petitioner got a notice of this from family court, then filed on criminal case against me. Thereafter, my lord, on March received, and in the month of May, filed criminal case against me. Then
Where that case is pending?
my lord, in Karimganj, after family court proceedings, my lord, they filed that case. And tomorrow yesterday I came to know another 125 case, my lord, lost against me. Now my humble submission in this case, since the one petition I filed to get my family get back, but the intention, my lord, 498 case, and the 120 intention is very clear that she's not willing to come with me, even though, my lord, if the restitution conjugal right petition, if lordship transferred, then what will happen? Then that same, well, that petitioner is already determined that I will not reside, stay with me, my lord. Therefore, 498, not me, my lord, my father, mother, 3 brothers, and my sister-in-laws all were made parties there, my lord. And
No,
my humble
we
in this case-
are not married
my
to
lord, here's
the
case, my
married to the
lord,
case.
ground they have taken in paragraph 7 that to come from Karimganj to here, my lord, the she has no money. This is the question involved here. I am having a 2.5-year daughter, and I don't have any income source. So this is the inconvenience, the ground she has taken, my lord. My humble submission in this point, my lord, Honorable Apex Court recently passed one decision, my lord, and landed all this point, my lord, and in Anindita Das case, Anindita and Shirijit Das reported 2006 and 10. It is reported recently, my lord, in the Gujarat High Court, and another judgment passed by it, my honorable my lord, this court, this people in Alikar, my lord, my lord. Here, this case, this point, regarding of inconvenience, we don't have any income source, my lord, and so far I'm having little children, my old parents, all gone into diluted, my lord, is that my lord, not considered, my lord. So, lordship, kindly lordship, allow me to this paragraph to read, then lordship will come to a conclusion, my lord. Whole his prayer already been discussed here also in this matter, squarely, my lord. So, my lord, such kind of transfer, even more, my lord, one decision passed by honorable appeals court. The other online system is also there, my lord. If she is sometimes days unable to come appear before this Guwahati, so online the family court she can approach, my lord. So for the crown, it is not necessary to transfer, my lord, and she's already made their family members already supporting her. 125 in the 190 case, and this matter go there. Why, my lord? So I am ready
To appear through the video conferencing, she must have the facility.
Of course, my lord, this means all the facility available.
If she cannot come to Guwahati to attend the proceeding,
my lord,
how can she manage
my last
the?
submission is, my lord, even, my lord, since honorable appeals court had, if the appellant is ready to pay the cost, along with the company who's accompanied with her, my lord, to come to this attend court and to state at Guwahati, my lord, I'm ready to bear the cost. And I'm hopeful, my lord, if the matter pending before the
No,
family
that's
court,
all right.
Guwahati,
You will bear the cost. But see the arduous journey she has to undertake from Karimganj to Guwahati.
my lord, first of all, to attend the family court, I have to come from Dubai. And my petitioner from Karimganj to Guwahati only. My lord, for whom I'm earning, my lord, for my family, my lord. If my lord, from Dubai to come Guwahati to Karimganj, Mike, I do work in corporate in the private sector, my lord. They don't allow me for 5, 7, 8 days, my lord. If a matter is pending before the family court Guwahati, so the same day I could return to my working place, my lord. So this is also very inconvenient to me also.
If the wife is required to appear through VC, then you can also appear through VC from Dubai. Why not?
But that facility is not available in the Karimganj, but it is available in Guwahati, my lord. So my humble submission, my lord, the proceeding going on the family court when we interfered, my lord, let my lord one final conclusion, my lord, so that my petitioner also not get suffered much, my lord. I also, my lord. So my last submission, my lord, If there is any possible for mediation, my lord, I'm ready to talk, my lord.
No, in transfer petition, we are not supposed to consider that
And-
aspect.
My lord, paragraph 7, page 7, paragraph 6 and 7, my lord, the grounds they have taken for transfer. Page 7.
Yes,
That the petitioner begs to state that and submit that the petitioner has been living with her parents since 24/7/2022. The father of the petitioner is all ailing retired person. The petitioner is dependent on her father's small income, and the petitioner has no source of income. The petitioner has two brothers. Younger brother is studying class 12, and elder brother is a government employee. Except the all ailing father, there is none to accompany the petitioner to Guwahati for attending the court. Moreover, the petitioner has 2.5-year-old child with whom it is almost impossible for the petitioner to attend the court at Guwahati, which is 350 kilometers away from her parents' house. In the above situation, it would not practically be possible to attend the court at Guwahati to pursue the proceeding so and so. Therefore, this instant petition has been filed before this honorable court in spur of the aforesaid so and so in district of Karimganj. Next paragraph, my lord. That the petitioner begs to that she has no sufficient means, and as such, she is unable to bear the traveling expenses, my lord, for the attending the court at Guwahati, which is at distance of 10 kilometers from Karimganj. The respondent husband filed the aforesaid case so and so in the court of Thane Principal Judge Family Court Guwahati only to harass the petitioner, and moreover, Principal Judge Family Court at Guwahati has no jurisdiction to try the aforesaid case, as is the cause of action arose at district of Karimganj. In the above pattern circumstances, honorable court may please to pass an order transferring this. This is on true grounds. First of all, that the elder brother or younger brother, they are elder working at a government job, and so most importantly, my lord, in paragraph 7, my lord, that she has no sufficient means to travel expenses, my lord. In this
no,
point, my lord,
Mr. Decker, the
My-
problem is that there are two paragraphs
yes.
numbering 7 in this petition.
Oh, my
I
lord.
don't know
It
which
is, my
paragraph
lord,
you are
that
reading.
is true, my lord. In me too also, my lord. Some and I have
You are, this page number, you are reading page number
7, my lord.
7.
7.
Yes,
But it is ought to be 9, but it is 6. Nine and 10, my lord. But it is if it is typed, it is 6, 7.
yes.
But in response to this paragraph, my lord, your lordship, I trouble your lordship, my lord. The affidavit in its objection I filed in this case, only one paragraph I would like to read here before lordship, my lord. At page 47, paragraph 7. I answered these two particular paragraphs, my lord. Only one paragraph I read. Lord.
Page number 47.
Yes, my lord.
Yes,
That with regard to the statement made in paragraph 6, 7, and 8 of the instant transfer petition wrongly numbered by the petitioner, the deponent vehemently denies the same, and in this regard, the petitioner deponent begs to state that the petitioner had filed the instant transfer petition by stating that she is unable to incur the traveling expenses to attend the family court in Guwahati, and she has none to accompany her, whereas the fact remains that the father of the petitioner is a retired person and her mother is also a government employee, and even her elder brother is also a government servant, and petitioner has also having younger brother studying 12 and younger sister pursuing BA degree. As such, inconvenience as raised by the petitioner is not acceptable, as such has sufficient means to incur the traveling expenses as well as to travel Guwahati to attend the honorable family court Guwahati. Moreover, petitioner is not willing to travel Guwahati from Karimganj to save her family and the future prospect of her baby, whereas the deponent is ready to travel from UA Dubai to Guwahati to attend the counseling process to save his family life. In this regard, the deponent begs to state that the Guwahati is the best place for both the parties, since the deponent is working in the UA Dubai who can attend the family court Guwahati after a overnight journey from Dubai to Guwahati, and deponent can also return back on the same day evening even after attending the family court at Guwahati, as there is available connection flight from the Guwahati to Dubai. However, it is almost impossible for the deponent to return back on the same day from Karimganj to Dubai, and since the petitioner is a corporate employee, his company will also not allow leave to the petitioner for frequent visit to Karimganj, which may require at least 5 to 6 days on every date of the court proceeding. Moreover, conveniently, between the Guwahati and the Barak Valley region is often marked with landslide, roads blocked, flood, and other natural disaster. And the deponent is under bona fide apprehension that the case, if he stuck in such calamities, he will definitely lose his previous job, for which he will not be able to either maintain himself or his wife and his child. The taking into consideration such aspect, and also for the sake of saving the precious family life, the deponent has filed the instant case Guwahati, and the family court in Guwahati will be the best place for adjudication of the instant FC case. Both the parties, and considering convenience, both the parties, this honorable court may please to displace the instant petition. Now, my lord, in support of this paragraph, I like to rely on two citations. Okay, dear. Please. First, I'd like to rely, my lord. Air Online 2019 Gujarat 755, wherein this honorable court, while passing this judgment, relied to honorable apex court judgments, my lord. I would try to rely, my lord, only one paragraph, paragraph 8, wherein Anindita Das case has been elaborately discussed, my lord. In the case of Anindita Das, may I read the paragraph 8, my lord?
Yes, yes.
Supra, the apex court has held us. 1. The transfer petition has been filed by the wife on the ground that the petitioner has a small child of 6 years. She has further claimed that she has no source of income and it is difficult for her to attend the court at Delhi. She has further claimed that she is not keeping good health. Number 2, she has relied some citation. Now 3, 4, my lord. Even otherwise, it must be seen that at one stage this court was showing leniency to ladies. But since then, it has been found that a large number of transfer petitions are filed by women, taking advantage of the leniency shown by this court. On an average, at least 10 to 15 transfer petitions are on board to each court on each admission day. It is therefore clear that the leniency of this court has been misused by the women. Number 4. This court is now required to consider each petition on its merit. In this case, the ground taken by the wife is that she has a small child and that there is nobody to keep her child. The child in this case is 6 years old and there are grandparents available to look after the child. The respondent is willing to pay all expenses for travel and stay of the petitioner and her companion for every visit when the petitioner is required to attend the court at Delhi. Thus, the ground that the petitioner has no source of income is adequately met, except for stating that her health is not good. No particulars are given on the ground that she is not able to come to Delhi to attend the court on the particular date. She can always apply for exemption and her application will undoubtedly be considered on its merit. Hence, no ground for transfer has been made out. Accordingly, we dismiss the transfer petition. We therefore direct the respondent shall pay all travel any stay expenses of the petitioner and her companion for each and every occasion when she is required to attend the court at Delhi. Thus, the Supreme Court has refused to entertain the transfer petition showed on the ground of inconvenience in traveling the distance. Now, my second question, or my second citation, my lord, 2004 to GLT 126, my lord, paragraph 2 and 3. In paragraph 2, that this petition under section 24 CPC filed by the wife for transfer of the suit filed by the husband for judicial separation in the court of district Judge Golaghat to the family court at Guwahati on the ground that the petitioner resides at Guwahati and has a 4-month-old daughter and therefore
From which part you were reading?
paragraph 2 and 3, my lord.
Yes.
I'll have to read again, my lord.
Not necessary.
Yes, my lord. Next page, my lord, at Guwahati and has a 4-month-old daughter, and therefore it is difficult for her to travel from Guwahati to Golaghat to contest the matter at Golaghat. Now, findings, my lord. Whenever a party approaches the court or is called upon to defend in the court, some sort of inconvenience is unavoidable, and inevitable result of the parties have to adjust their affairs in accordance with the schedule fixed by the court in a case. But that
cannot be a ground for transfer of a case from one court having jurisdiction to try the proceedings to some other courts having territorial jurisdiction or not. The inconvenience or difficulty contemplated under Section 24 CPC, the transfer of a case should be of such nature which may lead to injustice if the party is asked to continue the trial at a place where it has been instituted or when the court comes to the conclusion that a suit has been filed in particular court for causing injustice. As a general rule, the courts will not interfere and transfer a matter unless the expenses and the difficulties would lead to the injustice. In the matter of transfer of the case from one court to another, the main consideration is failure of justice, and therefore a case is to be made out that the party has a reasonable apprehension that justice will be denied to him. In that present case, the cause shown for transfer of the case is not of such magnitude where interference can be drawn that the petitioner will not be in a position to contend the case at the court at Golaghat, and non-transfer of the matter will result in failure of justice. Apart from this, as on today, the child is sufficiently old to travel with the mother whenever is called upon to appear in the case at Golaghat or to be kept at close relations. The matter is pending consideration in the Court of District Judge Golaghat, and therefore the petitioner can certainly engage the counsel to appear in the case, and it would not be necessary for her appear in the court each and every day. For the aforesaid reason, I do not find any case is made up for transfer of the case from the Court of District Judge Golaghat to Family Court at Guwahati. The petition for transfer is dismissed. However, the circumstance of the case shall be no order. Now, my submission means the particular the petitioner has raised that in having old parents, no one is there to accompany her. The financial, she has no sufficient means for traveling, my lord. These are already, my lord. This does mean I relate, my lord. My consideration, my only humble family in this case, my lord. I want my family get back. Therefore, I restitution file, my lord. So it is a very unfortunate that after lodging my restitution petition, my lord, one after another criminal cases filed against me and my family members, my lord. The intention very much
In
reflect.
connection with those cases, you have to appear before the court at
Not yet,
Karimganj?
my lord, issue, not yet, I received any issue or not. I will, next course of action, I will think about what would be done and that all these criminal matters. My humble say, this case, my lord, this matter may not be disturbed, we are pending in the family court, and I have confidence that if the matter is pending before the family court, definitely I will get my family back, my lord. If the matter sent back to the Karimganj matter, everything will go. Even, my lord, the job I am doing the UAE, for whom I am doing, not for earning for me, my lord. I am having a daughter and having a wife, my lord. If I lost my job in a private company, that in government company, it will be different. My lord. That private sector, my lord, they will never allow me. So that here if the matter is pending in Guwahati, so the same day I could.
No, nowadays, flights are available to Silchar also. If you can come to Guwahati,
No, my lord.
you can go to Silchar also.
There is no connecting flight, my lord. So from Guwahati is the convenient place so that I could attend. And though, my lord, the citation just I have derived before this court, considering already this apex court as well as this honorable court discuss all this point, I leave it up to your lordship, my lord. But my humble submission, and even, my lord, and though honorable court is the apex court recorded, if the appellant is ready to bear the traveling cost, I'm leave it up to you, lord. I'm ready, my lord. Bless me, lord.
Yes.
He is submitting about his convenience. But in page 48 of his objection, here it is categorically he has stated, your lordship kindly see page 48 of his objection. Page 48, in middle portion. Moreover,
Page number?
48. His objection.
Yes.
Moreover,
Yes.
the connectivity between Guwahati and Barak Valley region is often marred with landslide. Road blockade, flood, and other natural disaster. And the deponent is under the bona fide apprehension that in case if he is struck in such calamities, he will definitely lose the precious job for which he will not be able to enter. It is for himself, it is applicable for him. It is not applicable for me also. Because of calamity, it is blockade from Karimganj to Guwahati. It is also applicable for me. It is also, it admitted it is, there is a matter of inconvenience. There may be inconvenient for me. They are admitted it is also. So far, my lord, the cause of action. Yes, file a case under restoration of conjugal right. Mary Sullivan is at Karimganj.
everything, though both parties are from Karimganj, how this cause of action arose here at Guwahati? And in this regard, my lord, our High Court also passing odd judgment orders. Your lordship.
No, but have you ever raised this issue before the family court at Guwahati?
No, in the family court, my lord, we have not attended yet.
Not attended.
Not yet.
Acha.
Notice already has been issued. I have to bring my witnesses also from Karimganj. In this case, if it is at Guwahati, I have to bring my witnesses also. How it is possible for me, my lord, being a lady?
Yes, Mr. Dekka.
My
How
lord,
the
this-
family court at Guwahati has the jurisdiction?
My lord, this is a, my lord, inter-application, my lord. Just quick panel down. My lord, inter-application page 23 and XR 6.
Page 23.
Yes, my lord.
Yes.
This is a criminal case, my lord. In the first paragraph, my lord, inter-application. The accused persons are desperate and greedy persons of the same family. My marriage is solemnized with the accused number 1 on so as per the Islamic law. At marriage, my father had gifted so. I went to my house so. Now, my lord, my husband had a temporary address at
Is not well,
Acha.
as informed me yesterday. But lordship, this appeal is not maintainable in terms of section 23 subsection 2 of the Railway Claims Tribunal Act 1987. This is the
No,
lordship.
that's all right. Let her remain present. Let us fix a short date.
In the last occasion, she was there, lordship. And
Maybe, but
in
today
her
she is not.
presence, the matter was faced, lordship. On today's date, lordship.
Okay.
Lordship, if possible, kindly a short date maybe.
Yes.
Because this is a very old matter, lordship.
Itu 12 চনৰ 2000. We'll try on 12.
12th of September,
No.
13th August,
13th.
12 or 13?
13.
13. Okay.
13th August.
None appears for the appellant on call. However, Miss
M. Sharma.
M. Sharma, learned counsel for the respondent present. Lays the matter on 13.
Obliged.
Item number 5,
Lordship, I have a small prayer. I'm on behalf of MS.S. Roy, your Lordship, the arguing counsel in this case. She's Lordship hospitalized actually last week. She fell down in the High Court. Lordship, I pray for a little accommodation, your Lordship, for today.
No, accommodation, they say already 10 years, 14 years elapsed. No, 12 years elapsed. This is an appeal of the year 2012.
Lordship, only for today, matter may.
My lord, may I'm since kind of see the matter last order, my lord.
For the last time. What to do?
Lordship, I pray for accommodation only for today. She is not well. She is hospitalized, your Lordship.
Okay, heard, Miss. Your good name?
FN Jaman.
Learned counsel for the appellant, and Mr. Gupta, learned counsel for the respondents. Ms. Jaman submits that arguing counsel Ms.
S. Roy.
S. Roy is indisposed of and unable to appear before the court today, and press for listening the matter. On when?
on any Tuesdays, Thursdays?
Let it be on 13th, my lord. 13th.
13.
Yes.
13.
Yes.
Okay, 13.
Sorry,
It is further provided that no further adjournment will be granted.
Obliged.
Item 7.
Happy to lordship.
Yes.
But this is an appeal, my lord, against the reversal findings, my lord. And I am the plaintiff, my lord. And this appeal, my lord,
This is fixed for hearing today.
today, my lord,
The other side?
my lord. Lordship,
Who is the counsel for the other side?
SK Ghosh, even then he's very much ready. Even tomorrow also, my lord, very well, where this matter is listed today, my lord. Sorry, yesterday, my lord. And this is, my lord, the old pending case, my lord, the 2000.
14.
Yes. So maybe if your lordship heard me, my lord, so that my learned friends.
No, in absence of the other parties, would
Can
it
it
be
be
proper to hear
Can
you?
it be after some time, my lord? So that I.
Okay, after some time.
Yes.
Item number 8.
Please, your lordship.
Hmm.
The matter may be passed over for the time being, lordship. The
Time being.
time being.
Okay.
Item 9.
My lord, here, my lord, the last occasion, the appellant side was absent. And here, my lord, we are the decree holder, my lord. Suit was decreed in our favor. In the, it's of the cases of the year 2013, my lord. And decree was passed directing them to execute the sale deed. It's a case of specific relief act, my lord. So they have not executed the sale deed till now. So my young friend is saying that they want to engage a new advocate for the appellate. So my submission is that, my lord, this case is little urgent, my lord. Since 2013 onwards, my lord, they are not executing any sale deed. And in the court below has, my lord, found them, my lord, they have not filed written statement also. Then they try to file revision. That was also dismissed, my lord. And now here, my lord, they are, my lord, dragging this case, my lord. What is your mistake?
So, maybe advance 3 weeks.
Pardon?
3 weeks.
Why 3 weeks?
So, appellant said they engage some other advocate.
Yes, you can at any moment engage an advocate.
My lord, I can accommodate him, my lord. Thing is this, that, my lord, he is saying that earlier council was expired, my lord.
Acha.
DR group.
Gogoi, sir.
On
Acha,
that
acha.
point, my lord, I can accommodate. Only thing is that, my lord, a date may be fixed so that they can also.
Okay. Heard, Mr.
M. Ahmed.
M. Ahmed, learned counsel for the appellant, and Mr. Borua,
B. Borua.
a learned counsel for the respondents. Mr. Ahmed submits that earlier engaged counsel suffered demise, and the appellant will engage a new counsel and press for granting 3 weeks time to the appellant. Here is accordingly allowed. Recessal is the matter of COVID. 29th.
29 hours. Published.
Obliged.
Item number 10.
Other side absent.
Yes, madam.
Who was the counsel?
Sir,
Who was the counsel?
Jai Borja, sir. Jai Borja. Other said, my lord.
Is it present today in the court?
No, my lord.
No.
Yes, sir.
None appears for the appellant on call. However, Mr.
He was signing.
Learned counsel for the respondent present. List the matter on
Lordship, fix the date, my lord.
28.
28 August.
28.
In the event of subsequent non-appearance of the appellant, appropriate order shall follow.
Item 13.
So the matter was, my lord, time and again, my lord, listed for hearing. Each of the accurate matter could not have been taken up.
Please, lordship. Lordship, senior election, other, my lord, pass of time, my lord.
Okay, after some time then. Let us senior come.
Item 14.
For this case, Lordship, I've just prepared a small write-up
Mm.
with the judgments.
Mm. So, both the parties are ready to argue the matter?
Yes.
Ready.
Very small matter, my lord, here they have raised one dispute. that
Not
it-
small, Lordship,
Very, very
we
small,
are
frivolous-
alleging
frivolous
fraud.
dispute.
We are alleging fraud.
Okay, we'll see.
Apart
They have
from,
already paid the amount, compensation amount in another case. Same fact. I don't know why they have.
no,
raised
not
this.
same fact, Lordship. The other case is it was a death case. And in that, the accident, they said it took place on
Mm.
2nd October. Here, Lordship will
Not
first,
2nd October, 1st October. You have
first
admitted.
document, Lordship.
You have admitted.
Can I finish, sir?
Mr. Upadhyay, let her finish.
Yes.
Haven't it started?
Mm.
Thing is, Lordship, this particular gentleman, this is an injury case. This particular gentleman had taken his treatment on 1/10/2014 itself.
Mm.
And then he tried to change the dates and he,
Well, when the accident took place?
in fact, as per the FIR, Lordship, we have annexed that with our memo of appeal, Lordship, Annexer 2, and the type copy is Annexer page 13. The Assamese version is page 14, Lordship.
Mm.
In that, it is mentioned that the accident took place on 2/10/2014.
Annexer 2 is the FIR.
Yes, Lordship.
Yes.
The accident took place on 2/10/14.
What was the amount of compensation?
Amount of compensation, Lordship, was 12,41,580.
Injury case.
Injury case.
Acha. Was there any disability?
Disability, but we are challenging that also as because of Rajkumar Ajay Kumar judgment. What is the doctor who treated the injured did not adduce evidence. Only a person who gave the
No, whether the certificate, disability certificate was issued by a board.
He did not say that board, but it came. But he mentioned in his cross-examination that he had not treated. So, because Ajay Kumar, Rajkumar, I'll cite, Lordship.
Mm.
Therein it is mentioned that either the person who has treated, because he should be able to cross-examine the doctor who did not treat the claimant. Disability itself does not mean that there is loss of earning capacity.
Income, yes.
And no proof that due to injuries the claimant was not able to do his earlier work, or because they did not prove any work or anything what he was doing. They just said that he was a laborer, I suppose. He was a hawker in a bakery. That's what he said. That itself would not reduce his earning capacity to 35%. That also we are challenging based on what they have.
Mm.
But that comes later on, Lordship. First, we are on the allegation of fraud, Lordship.
Mm.
Because Exhibit 2 is the first document of his hospital, Lordship. Lordship will find it is in the blue file, LCR blue file. Lordship will find that the 2 has been overwritten with 1. Pagination is not there, Lordship, so I could not, I cannot read the pagination. That exhibit 2 and some exhibits are up and down, they are not in serial. If Lordship permits me, I can make it serial.
Yes, exhibit 2 is a medical document.
Yes, medical, that is the first medical document from Mongoldoy Lordship.
Mm.
Lordship will find that the date, Lordship, date is overwritten there.
Yes.
That's-
2/10/2014,
And it is made
overwritten
1/10.
as 1.
One, just to show that he had taken treatment on one. If he had taken treatment on one, to show that he had taken treatment on second. If he had taken treatment on second, then it is okay. But if he had taken treatment on first, Lordship, as per the FIR, the accident took place on second. So naturally, he took the treatment before his accident. And he just-
Accident took place on 2nd.
Second, that is the FIR, Lordship. FIR is filed by the wife of the wife of a person who died in the accident. And she has mentioned that the accident had taken place on second.
Mm.
And all his documents, Lordship, I'll show exhibit 3 also, date of admission is 1/10.
No,
Then-
but madam, did you cross-examine him on this exhibit 2?
Exhibit 2 cross examination, Lordship, I do not have. I do not have the cross examination.
This depositions are not available with you.
Position, Lordship, I think the doctor's position was there with me, but not the others. No, I do not have, Lordship. Lordship, I'll go through, Lordship can fix it on tomorrow.
Tomorrow?
Wednesday hearing में तो cross not
No, মোৰ তাত নাই।
cross
No, তথাপি চাব লাগিব। Cross, একো cross কৰা নাই নেকি? একো cross কৰা নাই।
you have not need any evidence, nothing.
নহয়,
No,
Cross
this
ei
point
কৰা
was
নাই
not
নেকি?
taken there.
No, cross ei কৰা নাই নেকি? কিবাটো cross কৰিছে চাগে, নকৰাকে কেনেকে লগ পায়?
মোৰ লগতো নাই।
On next Tuesday, then Lordship, Thursday already my matter are fixed in another court, Lordship, as number 1 item. So, but it can be on Thursday. I'll just might need some accommodation.
Thursday.
Thursday, I'll just go
Correct,
through
Thursday
the.
possible.
Tuesday, coming Tuesday, 13th. Next week.
Okay.
Coming Tuesday.
13. 13.
Then Lordship, my write-ups, can I take back?
You can take back, or else it may miss in the file. On the pair being made by Ms. R.D. Mazumdar, learned counsel for the appellant, with consent from the other side. Raise the matter on 13th. 13.
Difficult.
13 will be difficult.
Yes, yes.
15 to Thursday, বন্ধ হয় না আমার। 15 আমার independent.
Then suggested that
20 নহলে 22 হ'ব।
Tuesday or Thursday?
Tuesday, Thursday, 20 নহলে 22।
How about 22? 22.
22.
20. 22. 22.
22.
Yes. 20 or 22, either 20 or 22.
By Sirika. 22 then.
Yes, obliged.
Highly obliged.
তাতে হেৰি কৰি থক।
Item number 15.
Is the Lordship. Lordship, conducting counsel is lax in another court. Matter may pass over for the time being.
My lord, may I pray, my lord, a little accommodation is required because the assisting advocate could not come from Beltalaman because of the flood. Thursday, my lord.
Next Thursday.
This Thursday?
Thursday, a lot of matters fixed.
Any other day. And they have to produce one of the original will before the court.
Yes.
So they have to let them produce that also. Along with that, I'm ready for hearing otherwise. But today is some accommodation because of my assisting counsel, my lord, unable to come to court.
Okay. 28th.
28. They will produce the record, original.
Oh, was there any direction?
Yes, there was a note. 26/9. Original will be produced at, I think that is an order in IA. 20th. 20.
Okay, as agreed by learned advocates of both the parties, rescission is the matter on 28th. On that day,
Original will.
original will has to be produced before this court by who will produce?
The opposite party.
By the
Respondent.
opposite party.
Item number 16. May I please, Lordship? Lordship,
Yes.
this matter may be possible for signing by senior is on like in.
Timing.
Timing. Pleasure. Item 17. May it please, the Lordship. Lordship, in this case, this petitioner number 1, your Lordship. He has inherited property measuring about 4 bighas 17 gata from his forefathers, your Lordship. And for last 60-70 years, he has been in possession of the said land by constructing residential home, bonds, and other valuable.
But the other side is absent.
Other side is government is the other side.
Okay. Government side, এই ফুকন বুলি এগৰাকী আছে নেকি? ফোন নম্বৰ আছে যদি এবাৰ কন্টেক্ট কৰক। So Mr. Locker, after some time then, earlier we have seen one council.
Yes. Item number 18. Item 18. By order, please. Mention the clinic disclosed.
Mr. Sarkar, who is for the other side? H. Barua. Hmm? So you have mentioned the matter. Vijay Sunna, Vijay Mukherjee. Oh, okay, after some time then.
Item 19.
May please, Your Honor. Actually, they mentioned the case for listing. Lordship. Lordship, my senior assembly is out of station and I could not collect the file due to the heavy rain yesterday. Lordship. Could not attend the assembly yesterday. Lordship.
Then when to be listed?
Next week, Lordship.
Next Tuesday.
That may be fixed. Lordship.
Next Tuesday, not possible, lot of matters fixed.
Any date, Lordship.
22nd.
Lordship.
22nd.
Lordship.
Heard Miss
A Begum.
A. Begum, learned counsel for the appellant, and Mr.
M.H. Ali on behalf of Mr. A. Shahad.
M. S. Ali on behalf of Mr.
A. Shahad.
A. Sahal, learned counsel for the respondent. On the pair being made by Ms. Begum, learned counsel for the appellant, Recess, I'll list the matter on 22nd. Barta. No, no, निकला है कोई नहीं. After 15 minutes.
They have not present, they are not present.
Okay, none appears for the Everland on call. However, Mr.
M.H. Ali on behalf of Mr. UC Rava.
M.A. Saleh on behalf of Mr. Yusri Raba present. List the matter on when?
24th.
27th. 27/8.
Lordship. Obliged.
Timing item 13.
Yeah, absolutely. Matter is an appeal against my lord. The Lord district judge in connection with will, my lord.
But the other side is absent.
Other side.
What to do? I'm ready.
I may not, what I can say, my lord. Lord, if it is otherwise impossible, my lord, today, and Lord, can you fix
No,
the-
impossible. At 2 p.m. we can try then. If otherwise not inconvenient to you.
2 p.m., my lord, perhaps I might have another case, another court. This is the problem, my lord. Lord, then, Lord, can you fix the matter on 27th
27.
of August?
Okay.
Lord, kindly make an observation that last chance be given to the Lord respondent.
Okay.
Because they took several times, my lord.
Heard Mr. Purkasto, learned senior counsel assisted by Miss
SB Choudhury.
S.B. Chaudhary, learned counsel for the petitioner. None appears for the respondent on call. List the matter on
27th of August.
27. In the event of subsequent non-appearance of the respondent, appropriate order shall follow.
Timing item 16.
Still in the lake, Lordship.
Still.
At 2, your Lordship.
2. Okay. 2.
Timing item 17.
May I please, Lordship? Before submitting by my learned friend, I may be allowed to 1 week time, Lordship. I sought for instruction, Lordship, in this matter. Instruction has been received by me, but unfortunately, Lordship, I could not well prepared by this matter. That's why, Lordship, I pay for 1 week at least time, Lordship.
Heard Mr. M.S. Loskor, learned counsel for the petitioner, and Mr.
T.R. Gogoi, Lordship.
T.R. Gogoi, learned
Junior government advocate.
junior government advocate for the state for the respondents.
Lordship.
Mr. Gogoi submits that he has received instruction,
Lordship.
but some clarification is required, and therefore he press for listing the matter after a week. There is accordingly allowed. Recess shall list the matter on
Next Tuesday, Lordship.
22nd.
Lordship. Master.
Obliged.
Timing item 18.
So other side not present. Mukherjee. Ito.
Timing item 18.
Another date may be fixed, Lordship, giving as a last chance, Lordship. So many occasions they have not appeared.
No, he
Then-
has contracted the council, but At 2 p.m. we can try then. 2 p.m.
Coming item 3.
Other side absent. Huh?
At 2 or
So, okay, at 2 p.m. then. Any other method? No.
Coming item 7.
May I please, your lordship?
Yes.
At last my learned friends has come, my lord.
My lord, actually, I was in Lakes in port number 24.
Okay, but now are you ready to hear the matter?
Yes, yes.
Argue the matter?
Yes.
Yes.
I'm ready.
Okay.
Because it is a short point
Short
involved.
point involved.
Short point.
Yes, my lord.
Okay.
And here petition, my lord, appealant before lordship with the plaintiff number 2, my lord.
Page number?
Yeah, plaintiff, my lord, lordship, kindly have a look at page 6 that my plaintiff. I am the plaintiff appealant, my lord, plaintiff number 2.
Page 6.
Page 6, my lord.
Yes.
My name is my lord Gita Roy, is the present appealant, my lord. And earlier, my brother Sri Ananta Kumara, he has not approached this court, but I approached this court, my lord.
Mm.
Then lordship will find what is my prayer in my plaintiff, my lord,
Mm.
at page 10, paragraph 13.
So you were the plaintiff number 2
2.
in the original
Original
suit.
plaint, original suit.
Mm.
Our prayer in the original suit, my lord, the first prayer at page 10, my lord, paragraph 13, 1.
13-1.
Yes, my lord.
Yes.
Declaring that the judgment and decree dated 28/2002 entitled suit number 3 of 96 is a nullity being obtained by the defendant number 1 to 5 in collision with the defendant number 6 by playing fraud on the court. Our first prayer, my lord. And this is the only prayer, my lord. This is the only prayer, my lord. Ultimately, my lord, the trial court decided in favor of the present plaintiff, my lord. Then defendant approached before the learned appellate court, and appellate court reversed the findings of the trial court below, and appellate court impugned, my lord, findings at page 40. And this instant appeal, my lord, admitted, my lord,
Finding of the court is at page number
40.
40.
And judgment starts from 41, my lord. 40.
Yes.
Yes. From paragraph 3, plaintiff's case.
Yes.
The plaintiff case is narrated in the plaint may be discussed in brief. Is that the principal defendant number 1 to 5 filed a title suit being number 396 against the Brajendra Chandra Roy, my father name, my lord. Brajendra Chandra Roy, who expired in 2001, leaving behind the plaintiffs and defendant number 6 and pro forma defendant number 8. It is alleged in the plaint that the plaintiff number 1 left for his place of work at Golaghat and did not receive any summon from the court. And whenever he visited his house at Kalinagar, his brother, the defendant number 6, denied fact of the receiving any summons. It is stated in the plaint that on his last visit in the month of February 2004, the plaintiff number 1 came to know from local people that they will be evicted as a case against them has been declared. On being inquired about the matter, the plaintiff collected the certified copy of the judgment and decree and found that all the summons were received by the defendant number 6, my brother, my lord, where plaintiff's signature were forged as plaintiff never subscribed any wakalatnama as has been filed along with the petition seeking time to file a written statement in that title suit number censure and did not appoint K.M. Shingha as their advocate. It is further averred that the defendant number 6 in collision with the other principal defendants forced the signature of the plaintiffs in wakalatnama and other person got decree in title suit number censure and accordingly, under the aforesaid fact and circumstance, the plaintiff had instituted the inspection seeking declaration that the judgment and decree passed by the learned court of civil justice senior division Hailakandi dated 28/2002 in title suit number 396 obtained by defendant number 1 to 5 by fraud in collision with the
6 is a nullity. The defendant number 1 to 5 had contested the suit by filing the joint written statement containing inter alia that the Kulu Manu Singha should have been made party in the suit, and in the original suit, the plaintiff were duly substituted, served the notice, and summons appeared. Advocate so who conducted the case, and the defendant have prayed for dismiss the suit. Upon clearing of the following issues, number 1 is the action, cause of action. Number 2 is the 3 is the only question involved below. Whether the principal defendant number 1 to 5 obtained the degree entitled suit number so in collusion by suppressing the material facts. During the trial in the lower court, the plaintiff side adduced some witnesses and also exhibited certain documents. The defendant side adduced none. I have heard arguments advanced by the learned counsel on behalf of both the side at length and also scrutinized the materials on record, especially the LCR and the interim judgment and decree. In the instant appeal, the appellant has come up with this appeal on the ground that by the adducing evidence of PWs, the plaintiff's respondent side has failed to prove that the defendant number 1 to 5 has obtained the judgment and decree by fraud without serving any summons upon them, and in spite of failure in proving the same by the witnesses in the respective evidences, the learned court below had decreed the suit. So at this stage, there is no necessity to go to decide the other issues as framed in suit, but the convenience, the issue number 3 is discussed below. Issue number 3, para 10 below. PW1, in her statement, the present appellant below, PW1 in her evidence stated that during continuation of the title suit number 396, her father expired. Her brother, that is the plaintiff number 1, was at service at Golaghat and she was at her husband's homestead. PW1 also stated in her evidence that she and her brother, plaintiff number 1, have not received any summons in title suit number 396 as both were stayed outside, and when come to the homestead, incurred pro forma defendants, but they denied receiving of summons nor informed them the date of their case. The PW1 further stated in her evidence that the plaintiff number 1 and she came to court and came to know from the court that in their name, signatures have been forged in the title suit number so-and-so, where a Wakalat number dated 6/4/2002 is subscribed and a petition number 29/8/2002 has been submitted. But actually, the plaintiff number 1 has not put his signature in the Wakalat number as well as in the petition. The PW1 also stated that pro forma defendants number 6, in collusion with the defendants, concealed the facts before the court by misleading the court and obtained the decree in the title suit number so-and-so. The learned counsel for the defendant side duly cross-examined the aforesaid witnesses in her cross-examination. The PW1 has stated that her residence is at Silchar, the Petukandi, and she does not put her signature in Exhibit 1, but her name is appearing there and cannot say who wrote her name. Now PW2. PW2 in his evidence has stated that during continuation of the titles so-and-so before the evidence states, his father expired and he was at his service place at Golaghat, and his sister, that is the plaintiff number 2, was at her husband's house. The PW2 also stated that they left for their workplace and their addresses was known to the defendants, but the defendants never sent any summons to them nor informed the date of the case, and while they came to home, they were not informed about the date of the case, rather denied receiving of summons. The PW2 also stated that he came to know that one Wakalatnama dated 26/4/2001 by forging his sister's signature. Same was submitted before the court, and also by forging his as well as his sister's signature, a petition dated 29/8/2002 has been submitted, whereas he and plaintiff number 2, this is PW1, did not file any Wakalatnama nor file any petition in the title suit so-and-so. So PW2 also stated in his evidence that the main defendants, in collusion with the pro forma defendants, forging their signatures in order to outstamp legally from the property submitted and petition before the court and misleading the court, obtaining the decree that so-and-so. Paragraph 13 and 14, 15. This is very important. On close scrutiny of Exhibit 1 reveals that in Wakalat number dated 21/4/2001, in title suit number 396, signatures of the PW2 Ananta not appeared, and only name of the PW2 Gita Roy's signature seems to have appeared, but the Gita Roy's signature seems to have appeared, but the same was denied by the PWs. But the plaintiff has failed to prove or challenge the said signature that it is not her signature. Rather, someone forged the same, and in this respect, it was the duty of the plaintiff to send the said signature to an expert for examining the said signature. But the plaintiff's side was absolutely silent in this respect. I will argue on this point, paragraph 14 later below. Similarly, in Exhibit 2, the petition number so-and-so dated 29/8/2002, entitled suit number 396, where signatures of the plaintiffs appeared, and both the plaintiffs have denied those signatures as those were not their signature. Rather, someone has forged the same. But the plaintiff side, in this respect, also utterly failed to take any step to prove or challenge that those signatures were not their signature. Rather, someone has forged the same. And in this respect, it was the bounden duty of the plaintiff to send the signatures to an expert for examination, etc. But plaintiffs will absolutely remain silent in this respect. So, from the analysis on record, it is apparent that the Wakalatnama Exhibit 1 and the petition dated 29/8/2002 Exhibit 2, the signatures of the plaintiff are admitted fact as both the plaintiffs in their respective evidence as well as in cross-examination admitted that the signatures appeared in Exhibit 1 and 2 are their signatures. However, they have no knowledge who put those signatures. But as discussed above, it is the bounden duty of the plaintiffs to prove or challenge the same by an expert, but they did not in this regard, and according to this issue in this answered negative. Yes, Milord, considering this paragraph 13 and 14, this honorable court will frame the question of law, Milord. Lordship will find, Milord.
At page number?
Milord, order, Milord. Order dated 24/9/2014, Milord. Frame three substantial question of law, but only one. On one.
Yes.
That the further the substantial question of law involved in the case is that whether the learned appellate court below was correct in reversing the finding of the learned trial court below without proper examination of the signatures of the plaintiff through expert evidence. That is under section 73 Evidence Act will come here in this case. My only substantial question that is then Lord the court is despite Lord section 73 lordship kindly I like to pray I pay lordship kindly section 70 evidence Lord. In new one is new act
Evidence.
In old one is 73.
Yes.
My lord. 73. The comparison of signature, writing or seal with others admitted or proved. In order to ascertain whether a signature, writing or seal is that of that person by whom it purports to have been written or made, any signature, writing or seal admitted or proved to be satisfaction of the court to have been written or made by that person may be compared with the one which is to be proved, although that signature, writing or seal has not been produced or proved for any other purpose. The court may direct any person present in the court to write any words or figures for the purpose of enabling the court to compare the words or figures so written with any words or figures alleged to have been written by such person. Here in this case, my lord, it is clear, my lord, that section 73, my lord, certain liberties also given to the court, my lord. Simply, my lord, learned appellate court has held that
So your contention is that the appellate court had not compared the signatures.
absolutely, my lord, and then it is burden to us that plaintiff to send the say signature to an expert and examine the signature, my lord, in both paragraph 13 and 14. And on this, considering this to my lord, that question of law is framed in support of my case, my lord, what the apex court and this honorable court on this particular point, what the findings, my lord, what ought to have been done by the appellate court is discussed here, my lord. Don't see, I got it right. This is the only question involved in the paragraph. If I'm able to establish my case under section 73, then I have a case. Then otherwise, my lord. In my lord, first case, I like to rely, my lord, Air 1997 Supreme Court 3255, that is Ajit 7 Majagavi, an appellant state of Karnataka responded, my lord. Here, three paragraphs I'll read, paragraph 36, 37, and 38. In paragraph 36, the original records were also placed before us, and we have perused those records. Since learned counsel for the appellant contended that the appellant had not stayed in the Ashoka laws, we look into the register of lodgers. It contains the relevant entry against such signatures of the appellant who appears. His signature also appears on the Wakalatnama filed by him in this appeal in the presence of the learned counsel for the parties. We compared the signature of the appellant on the Wakalatnama with the signature in the register of lodgers. A mere look at the signature was enough to indicate the similarity, which was so apparent that it required no expert evidence. This comparison was done by us having regard to the provision section 17.3 of the Evidence Act, which provides under skip it, my lord, section 17. Now paragraph 37, my lord. This section consists of two parts. While the first part provides for comparison of signature, finger, impression, writing, etc., illicit written or made by a person with the signature or writing, etc., admitted or proved to the satisfaction of the court to have been written by the same person. The second part empowers the court to direct any person, including an accused, the present in court, to give his specimen, writing, or fingerprint for the purpose of enabling the court to compare it with the writing or signature illicitly made by that person. The section does not specify by whom the comparison shall be made. However, looking to the other provision of the Act, it is clear that such comparison may either be made by the handwriting expert under section 45 or by anyone familiar with the handwriting of the persons concerned as provided by section 47 or by the court itself. Para 38, my lord. As a matter of extreme caution and judicial sobriety, the court should not normally take upon itself the responsibility of comparing the disputed signature with that of the admitted signature or handwriting, and in that event, the slightest doubt leave the matter to the wisdom of experts. But this does not mean that the court has not the power to compare the disputed signature with the admitted signature, as this power is clearly available under the section 17 of the Act. Now, my second, my lord, citation, I like to rely, my lord, that's Kerala High Court.
But Mr. Deka,
My lord,
after perusing the section,
my lord.
it appears that it is not mandatory. Court may not compare itself.
My lord, then my lord, court is burdened. Why you have not sent your signature to for expert? It is the duty of the court to send this matter. Since the whole dispute is involved, that point only, my lord. Now, Kerala High Court, my lord, 1988 Criminal Law Journal 1000, my lord. Here, para 9, 11, and 14.
You see the wording of the section. That person may be compared. May be compared with the one which is to be proved.
This particular section 17, my lord, just the citation I relied, my lord, Apex Court had discussed this issue, my lord, and in this Kerala High Court also, my lord, elaborately discussed this point, my lord. That question lordship justice put to me. In para 9, 11, and 14, 3 paragraphs. In para 9, in the Indian Evidence Act, just like in English law, that recognizes the proof of handwriting by admission of person who made it or by evidence of witnesses who show it written. There are 3 other methods of proof by opinion, and they are: number 1, by the evidence of handwriting experts as provided section 45, number 2, by the evidence of witnesses acquainted with the handwriting, not expert, as provided under section 47, and number 3, by the opinion formed by the court on comparison made by itself as provided in section 73. All these 3 methods involve a process of comparison. A sample taken by the court under the second paras of section 73 is really the admitted written within the meaning of the first para also. The first para also provides for comparison, but does not specify by whom the comparison is to be made. These 2 paras, section 70, are not mutually exclusive, but they are complementary to each other. There cannot be any dispute that the comparison mentioned in the first para could be as provided in section 45 and section 47. If section 73 is read as a whole in the light of the section 45 and 47, it is clear that the court does not exceed its power under section 73 if, in the interest of justice, it directs any person present in the court to give his sample writing enabling the same to be compared by an expert. Because even in adopting such a course, the ultimate purpose is to enable the court to compare a disputed writing with a handwriting, admitted writing. Now, para 11, Milord. What emerged from the discussion is that the court does not exceed its power under Section 73 of the Evidence Act if, in the interest
No,
of the,
Mr. Decker,
my lord,
power is there. There is no dispute about it. But what would be the consequence if the court chooses not to exercise that power?
but the court has lordship already. The Kerala High Court is there are 3 options, my lord. But here in this case,
No, you kindly appreciate my question.
my lord.
Then what would be the consequence if the court does not resort it to the Section 73?
Therefore, my lord.
This is not mandatory also.
But my lord, in the my whole case is based on, since I am disputed that this is not my signature, my lord. To come to a reasonable conclusion, my lord, isn't that the duty of the court either to compare, since I am available?
No, burden of proof is upon whom?
Court is burden to me, plaintiff. Burden given to me, my lord. Court is specific, the language of the court, my lord, that the plaintiff has failed to prove or challenge the said signature, my lord. It's very important. To prove or challenge the said signature that it is not her signature. Rather, someone forced the same. In this respect, it was the duty of the plaintiff. Duty of the plaintiff, has said, my lord, to send the said signature to an expert for examining the said signature. Why, my lord? Why plaintiff? Since I am disputing my signature, the why will send to the expert? It is up to court. Court, well, if court has some doubt on my signature, the court could have asked the expert, yes, he compared their signature, whether this was same or different, my lord. Then court could have come. Then why should since I am disputing again, I have to send my expert, then I have to get that record and I have to place. No, my lord, it is in my favor or against me. Why court will believe that expert opinion? So it is the independent to come to independent in the my lord. It's the duty of the court. Yes, since I am not myself comparing, it is not, since it is not a mandatory that I should compare in this case, since expert is the only, since I am available, so court could give some specimen so that I could send it to expert, an expert. After getting the expert, I will come with. But same has not been done, my lord. And paragraph 11, my lord. What emerges from the discussion is that the court does not exceed its power, Section 73 of the Evidence Act, if, in the interest of justice, it directs a person appearing before it, whether it is a civil or criminal court, to give sample writing to enable the same to be compared by the handwriting expert. Because even in adopting this course, the purpose is to enable the court to compare the disputed writing with the admitted writing and to reach its own conclusion with the assistance of the expert. There is nothing in Section 73 which outs the jurisdiction of the court to getting the opinion of an expert by comparison of the disputed and admitted writings in order to enable the court to compare the specified writing in the disputed one to reach its own conclusion. Notwithstanding the fact that in the first instance, the court thinks it necessary in the interest of justice to have advantage of the opinion and assistance of an expert. Now, finally, paragraph 14, my lord. So I am of the opinion that the magistrate was well within its competence when he gave a direction under Section 73 for the purpose of comparison by an expert to enabling him to form an opinion by the comparison. No illegality or abuse of process of the court is involved, justifying interference by this court because the ultimate object and purpose is to decide in the interest of justice whether PWP2 was retained by the petitioner or not. A decision on that question is relevant to enable the court to come to a proper finding on the disputed questions. I do not understand why the petitioner is so much aggrieved by that order. If the letter was not written by him, he need not have to worry about comparison by the expert. If it otherwise the duty of the court to arrive at that truth. And in that case, court has sent back to the expert, and when he found that expert opinion that it is not tally, then against the petition. But here in this case, the court ought to have been sent to the, instead of asking me, you go for expert, then you come to court. So court, it is the duty of the court exercising this provision, my lord, to send them my signatures to the
duty of the court.
yes. And as thus I have relied a lot to come to a reasonable and thus findings a lot is a duty. My final citation I have to rely a lot. This is Andhra Pradesh High Court a lot. Yes. Para 5(6). Under section 72 of the Act, the court is empowered to ascertain whether signature, handwriting, or seal is that of the person by whom it purports to have been written or made, and compare any signature, writing, or seal admitted.
No, where is the ratio of the case?
Para 16, my lord.
6.
6.
Okay.
Since the court below has formed an opinion that it can be itself undertake the exercise of comparison of signatures between the admitted and disputed document, it cannot be said that the discretion exercised by the court below is either unsound or irrational, calling for interference of this court in exercise of the supervisory duties under 27 Constitution of India. In that case, my lord, the Lada trial court has compared that itself and gave the finding, but here same has not been done. My humble submission, my lord, in the appellate court in paragraph 13 and 14, my lord, given it's the bounden duty of plaintiff, send the signature to the expert. I'm agree on that point only. Now, my lord, this is a court.
No, you could not answer my question. What would be the consequence if the court chooses not to exercise that power?
Then, my lord,
73.
suppose, my lord, court has not exercised this section 73. Then ultimately the findings taken me, I failed because since I'm not go to the expert to prove my signature and getting that records, and I failed to please the court. Ultimately, that's when evicted, you know, whole case that earlier suit was I challenged by forging our signature, they obtained a decree, my lord, and ultimately court has also said under section 73 has not either compared itself or sent to the expert. Then what consequences, my lord? I lost my case, my lord. Since there is this 45,
Did you made any prayer before the court at the time of hearing?
No.
For sending the disputed signature
Lord.
and the admitted signature?
My humble submission is, since I'm admittedly, my lord, I'm disputing this is not my signature. Yes, but it is not a duty. Since court has to decide only one point. Yes. How court could held in paragraph 15 said that paragraph 15, my lord, on what basis, my lord, that they said they have admitted that signature in exhibit 1 that their signature. How court could arrive that finding? Neither court has compared by itself, not getting any report from expert. How the court can say that the exhibit 1 and 2 is signature admitted, my lord? I'm agree on that point, my lord. The court itself compared or send it to the expert, my lord. If any adverse report comes against me,
You were referring to the paragraph number
15 also, my lord.
15 of the judgment.
Yes, 13, 14, and 15. This is the important paragraph. We said yes, this is our signature, but we're disputing it, but not by us. There is no evidence, no examination, but simply said yes, we admit it. আচ্ছা রহাসু পাইছো
Yes, Mr. Ghosh.
My lord, here in this case, my lord, only question is that he has not contested the suit earlier after death of his father, and suit proceeded ex parte against them, and this is the basic contention. So the decree which I have obtained earlier, that is nullity. This is the only prayer. Now kindly see one paragraph from appellate court judgment. I will show page 45, paragraph 15. So from analysis on record, Lordship got
Paragraph
15, 1-5.
Yes.
So from analysis on record, it is appeared that Wakalatnama Exhibit 1 and the petition dated so and so Exhibit 2, signature of the plaintiffs are admitted fact as both the PW in their respective evidence as well as in cross-examination admitted that the signature appeared in Exhibit 1 and 2 are their signature. They have no knowledge who put this signature. Now, when they have denied this signature, it is the duty on the plaintiff, because they asserted that this is not our signature. They have not filed application to resorted the section 73 that our signature should be put to it should be expert. It went to the expert for examination. Now, what duty on the plaintiff or what duty on the defendant? Kindly see, my lord, section 102 of the Indian Evidence Act and 103. Without reading 102, 103, he straightway duty has been cast upon the court, that it is the duty of the court who will send the expert question signature to be expert opinion. My lord,
Burden of proof.
on whom 102, kindly say.
Yes, yes.
On whom burden of proof lies. The burden of proof in a suit or proceeding lies on the person who would fail if no evidence at all were given on either side. Now, 103, burden of proof as to a particular fact. Here is a particular fact he wants. The burden of proof as to any particular fact lies on the person who wishes the court to believe it in existence, unless it is provided by any law that the proof of that fact shall lie on a particular person. Here, he himself or said that this is not my signature. So burden of proof on them that this is not my signature. How to prove? It is the duty of the person who has asserted that this is not my signature. Now, in this respect, I will show two judgments of the my lord, kindly see the judgment of 2013 to SCC 606 Gain Chandra and Brothers versus Ratan Lal. It is by the Honorable Supreme Court K.S. Radhakrishnan and Deepak Mishra. Paragraph 21. The present case is not one such case where the plaintiff have chosen not to adduce any evidence. Here they have adduced evidence. They have examined witnesses, proven entries in the books of accounts, and also proven the acknowledgement duly signed by the defendant. The defendant, on the contrary, except making a bold denial of the abutment, had not stated anything else. That apart, nothing was put to the witnesses in the cross-examination when the document were exhibited. He only came with a specious plea in his evidence, which was not pleaded. Thus, we have no hesitation to holding that High Court has fallen into error in holding that it was obligatory on the part of the plaintiff to examine the handwriting expert to prove the signature. The finding that the plaintiff had failed to discharge the burden is absolutely a misconceived in the facts of the case. Here in this case, the High Court held that the submission, that it is the duty, court has not examined the particular signature. The Supreme Court held that no, it is not correct. Then now kindly next page. In our opinion, approach of the High Court was not correct. It failed to apply the legal principle as to contain the Order 8, Rule 3 and 5 of the Code of Civil Procedure. The High Court had also not analyzed the evidence adduced by the on behalf of the appellant in his behalf in detail, but merely rejected the same summarily stating that Hague statement had been so and so. Now, burden of proof. Yes. Oh, and then in this judgment, paragraph 17 can you see?
Paragraph?
Paragraph 17. The judgment I am reading. It is well settled principle of law that person who asserted a particular fact is required to affirmatively establish in Anil Rishi versus so and so. It has been held that the burden of proving the fact rests on the party who substantially asserted the affirmative issue and not the party who denies. Here in this case, he has asserted that this is not my signature. It is not that I have asserted. That is, the defendant has asserted. Who had denied it, and the said principle may not be universal in its application, and they may be in exception thereto. The purpose of referring to the same is that if a plaintiff assert that the defendant had acknowledged the signature, it is obligatory on the part of the substantiate the same. But the question would be, what would be the consequences in a situation where the signature are proven and there is an evasive reply in the written statement, and what should be the construed as a sustain that the assertion made by the plaintiff. In so and so, when fraud, misrepresentation, or undue influence is alleged by a party in a suit, normally the burden is on him to prove such fraud, undue influence, or misrepresentation. This judgment has been quoted. This is against him, my lord. And another judgment, my lord, I have given 2005 SCC 558. This is Anil Rishi versus Gurbat Singh. Paragraph 8.
Yes.
It is initial burden of proof would be on the plaintiff in view of section 101 of the Indian Evidence Act. 101 burden of proof, whoever desire any court to give judgment as to any legal right or liability depend on the existence of fact which he assert must prove that those facts exist. When a person is bound to prove the existence of fact, it is said that the burden of proof lies on that person. In terms of the said provision, the burden of proving the fact rests on the party who substantially assert the affirmative issue and not the party who denies it.
Yes.
Said rule may not be universal in its application, and so under such circumstances, court duty, when there was no such application under for resorting section 73, court of its own. It is the power of the court of its own can compare the, and it is compared and found PW1 paragraph I have read out, paragraph 15 of the appellate court judgment.
Appellate court had compared it.
Paragraph 15,
Yes.
page 45.
Hmm.
So from analysis on record, Lordship got it.
Yes, got it.
It is apparent that Wakalatnama Exhibit 1 and the petition dated so-and-so Exhibit 2 signature of the plaintiffs are admitted fact, as both the PW in their respective evidence as well as in cross-examination admitted the signature appeared in Exhibit 1 and 2 are their signatures. However, they have no knowledge who put this signature. How can it?
No, Mr. Ghosh, one thing, it is not clear that whether their names may be there, but they might admit,
My lord, then I
but
will
they may not admit their signature.
now I will show another paragraph
Of the judgment,
of the judgment where
appellate court.
appellate court and both the court that
Okay.
he was aware about the proceeding earlier. He met with the lawyer also. Lawyer said, no, you did not, right now you did not require to come.
Acha.
And
Which paragraph?
And in that case, one of the legaliar who has filed the Wakalatnama, he has not come to the suit, nor he has come
No,
to the.
let us see the evidence here. Let us see the evidence.
Yes. Evidence of evidence. Evidence. They are evidence.
They have not adduced.
No, we have not. Our question.
No, his evidence.
Evidence.
Huh.
Evidence. Fine. Yeah, no. It is in Bengali, my lord. May I read?
Yes.
আমি ও আমার this is গীতা রায় আমি ও আমার ভাই অনন্ত কুমার রায় এই মোকদ্দমার বাদী বটে। আমরা এই মোকদ্দমায় অত্র আদালতে সত্য 3/1996 নম্বর মোকদ্দমার ডিগ্রি ও অবৈধ for declaration nullity আর then do 2 সত্য 3 of 1996 মোকদ্দমা এই মোকদ্দমার মূল বিবাদীগণ আমাদের পিতা ব্রজেন্দ্র কুমার রায়ের বিরুদ্ধে আনয়ন করিয়াছিলেন, যেখানে ওই মোকদ্দমায় বাদীগণ অর্থাৎ বর্তমান মোকাবেলার মূল বাদীগণ মোকদ্দমার মূল বিবাদীগণ আমাদের বসত বাড়ি হইতে আমাদের পিতার উচ্ছেদ প্রার্থনা করিয়াছিলেন, এভিকশন সুট। ওই মোকদ্দমায় আমাদের স্বর্গীয় পিতা তাহার জবাবে বর্ণনা করিয়াছিলেন যে ওই মোকদ্দমা তফসিল বর্ণিত জমি তিনি বিগত 29/11/61 ইংরেজি তারিখে 6979 নং রেজিস্ট্রি দলিল মূল্যে নরেন্দ্রচন্দ্র নস্করের উত্তরাধিকারী হইতে করিয়াছিলেন। সত্য মোকদ্দমা সোয়েন্সো মোকদ্দমার চলাকালীন মোকদ্দমার সাক্ষী
Mr. Ghosh, let us directly go to the Exhibit 1 and Exhibit 2 in the evidence.
My lord, this is also important. They were aware there was a suit.
Acha.
They were aware. One of the legaliar contested also after death of father. And other legaliars who has filed this suit, they have also aware that there was a suit, but they went to the lawyers. Lawyer says that right now need not require to come.
That evidence is there.
Yeah, that is why I am reading. পিতা মারা যান সেই সময় আমার ভাই 1 নং বাদী আসামের বাইরে যাওয়ায় হিসাবে গোলাঘাটে কর্মরত ছিলেন এবং আমি আমার স্বামী বাড়ি আমার বর্তমান বাসস্থানে ছিলাম। আমরা উভয়ে পিতার মৃত্যুর খবর পাইয়া পিতার বাড়িতে আমি এবং সোয়েন্সো কাজ সমাধান করার পর 1 নং বাদী কর্মস্থলে যাওয়ার পূর্বে আমাদের পিতা নিযুক্তি ইম্পর্টেন্ট আই এম রিডিং নিযুক্তিক অধিবক্তা কুলমণি সিং এর সঙ্গে দেখা করে মোকদ্দমার খবরাখবর নেন। That is after death, they take information from the lawyers about the suit. নেন এবং তিনি পরামর্শ দেন যে আদালত হইতে সামন প্রাপ্ত হইলে মোকদ্দমার প্রতিদ্বন্দ্বিতা করিতে হইবে, অন্যথায় নয়। আমি বা আমার ভাই 1 নং বাদী 600 তারিখ মোকদ্দমা অদ্যবন্ধি মোকদ্দমার সমন প্রাপ্ত হইয়া আমরা উভয়ে বাহিরে থাকি এবং বাড়িতে আসিলে মোকদ্দমা বিবাদীগণকে সমনের কথা জিজ্ঞাসা করিত, কিন্তু তাহারা কখনো সমন প্রাপ্তির কথা আমাদের জানায় নাই বা মোকদ্দমা কোন তারিখ কিংবা মোকদ্দমায় আবার চলিবে কি না তাও জানায় নাই। আমরা ভাই 1 নং বাদী নিয়া বিগত ফেব্রুয়ারি 2004 ইংরেজি সনে বাড়িতে আসিলে আশেপাশের লোকজন তাহাদেরকে বলা বলি করে যে পিতৃবিদ্যে হইতে তোমাদের বর্তমান মোকদ্দমা মূল বিবাদীগণের উচ্ছেদ করিবেন, সেই জন্য আদালত হইতে তাহারা ডিগ্রি প্রাপ্ত হইয়াছেন। That decree was not challenged. Even if suppose legal heirs were not substituted, legal heirs were substituted, they have not received the summon out of some of the legal heirs, some have contested, some has not contested. That decree has not challenged. Now some of the legal heirs came, no, we have not received the summons. But it was contested by their predecessor. Degree then নাই, তারপর 1 নং বাদী অধিবক্তা কুলমণি সিং এর কাছে খবর নিলে তিনি জানান যে মোকদ্দমা আমাদের বিপক্ষে গিয়াছে। ইহার পর 1 নং বাদী এবং আমি আদালতে খবর নিয়া জানিতে পারি যে আমাদের নামে সহি জাল করে সত্য এত ইংরাজি মোকদ্দমা একখানা ওকালতনামা 26/4/2001 তারিখে সম্পাদন করা হইয়াছে এবং 19/8/2002 তারিখে একখানা দরখাস্ত জমা দেওয়া হয়েছে এবং 1 নং বাদীর নামে কোনো ওকালতনামা বা দরখাস্ত আদালতে নামিতে নাই। That means only ওকালতনামা and this is in the name of Gita Rai. এবং 6 নং মোকদ্দমা সাক্ষী বাদী দিয়া কোন রূপ প্রতিকার নেন নাই এবং বাদীগণের নামে যোগাযোগে সকলে মিলিয়া আদালতে হইতে সত্য গোপন করে আদালতে ভুল পক্ষে পরিচালিত করে প্রতারণা করে সোয়েন্সো। এই মোকদ্দমার প্রমাণ সাক্ষী হিসাবে প্রদর্শক 1 3/1996 মোকদ্দমা 26/4/2001 তারিখে দাখিল করা ওকালতনামা আমার সহি জাল করা হইয়াছে। আদালতের সোয়েন্সো ইংরেজি মোকদ্দমার এত তারিখের দাখিল করা এত দরখাস্ত সমেত আমার এবং 1 নং বাদীর সহি জাল করা হইয়াছে। প্রদর্শক 3 সোয়েন্সো। নাও ক্রস এক্সামিনেশন পার্ট। I'm skipping first portion. I appeared in SSLC examination but failed. I do not put my signature in Exhibit 1, but my name is appearing there. I cannot say.
It does not mean that she has
She has,
admitted. Ah.
yes. So it is,
So her name appeared there, but
it does not mean that it is his signature.
yes.
Yes.
Hmm.
Now it is the duty or it is the burden on him that it is not my signature. Then he will have to file application for regarding section 7 for resorting section 7.
No, this finding of the appellate court that admitted, she has admitted. Where?
I cannot say who has written the name or exhibit 1. I have no suspicion.
Appearing name and putting signature are the two different things.
No, then I am coming. My sister's name is Sita. Sita is her husband's house at so and so, father's house. Sita is also past so and so. I do not know Sita's writing and signature, but I and Sita continued our study, living in the same family. I cannot say who wrote the name of Sita Roy. Exhibit 1, Sita is married to one so and so, and my father, brother, and I myself write our title as Roy. My father left the so and so. After expiry of my father, Ananto and Omullo discuss about my father's case with us, and we resolved to continue with the father's case and left the matter with Omullo and Ananto to do the needful. So Gita
So
Gita.
they were
Gita,
aware of the.
Aware, not only aware, it's specific. After expiry of my father, Ananto and Omullo discussed about my father's case with us. And we resolved to continue with the father's case and left the matter with Omullo and Ananto to do the needful. So Gita is lady, he married. She, not me, she. And brothers has been given power to contest the case. Suit was contested by brother and it was decreed. Now he said that no, it was, I have not signed all this. Even if it is not signed, suppose, even if it is not signed, whether it is sufficiently represented or not, the state of the father who has claimed. The state of the father was sufficiently represented because other heirs were parties and they were aware also. Not that it is not, they were not aware. The allegation is that they have not received summon, so it is a traditionality.
So it is the evidence of PW1
Yes.
and PW2 taken.
PW2. Ananto Kumar.
Acha.
Straight away I go to the
Yeah,
cross exam.
to the point.
Exhibit 1, the name of Sita, Gita and Omullo appeared. But I cannot say who put those. There are 3 signatures. Only Gita said.
No, signature and name are two different things.
No. Again,
Their name may appear there.
No. Again, I am reading. It is Ananto Kumar. Ananto Kumar. And earlier was Gita. Exhibit 1, the name of Sita, Gita and Omullo appeared. Sita, Gita and Omullo. Two only came to the witness. I cannot say who put those. I cannot say who has done. Exhibit 4 contains the name of legal heirs of the Gajendra Roy. But I cannot say who put the signature in marked Exhibit X on the backside of the Exhibit 4. That is summon. I left the house on so-and-so. Before that, I used to reside with my mother and brother Omullo. Omullo read up to class 4. We were in the same mess before I went to service. Up to 2001, I was member of the same mess. I got separated in the year 2001 and I was married yet. After 2001, I have relation with my brother and sister, and I visited the house occasionally during leave period. I had no litigation or I have no litigation or enmity with my brother Omullo. Cordial relation was there. Omullo is not party in this suit. Omullo has not filed this suit. One of the legal year. So there are three signatures, Onanto, Gita and Omullo. Two has come said, I do not know who has put this signature. In one witness has said that we have given in cross-examination, he has given power. After an expiry of my father, Ananta and Amullo discussed about my father's case with us, and we resolved to continue with the father's case and left the matter with Amullo and Ananta to do the case. So, in view of the above, it is this substantial question of law is not involved in this case because it is the burden on the plaintiff. Even if he asserted that, yes, I have not signed it, this is the fourth signature, suppose, who will prove it? He will have to prove it. Only mere assertion has been made that this is not. Apart from that, whether the earlier suit was which was decreed, whether that state of the legal layers were sufficiently represented or not. That was sufficiently represented because one brother has not said that this suit is collusive suit.
No, Mr. Ghosh, we have to confine only within the framework of this
Substantial question of law. Yes. That
we
is
have to confine.
yes.
Anyway,
My lord.
yes, any reply?
Yes, my lord. My lord, admittedly, my learned friend has cross of the PW1 and 2 has seen. Though in paragraph 15 of the interim judgment, my lord, it said that we admitted, but from their reading of the evidence, my lord, it said that our name is there, but we're disputed. This is clear, my lord, and I leave it up to your lordship now. No, where we
Okay,
admitted.
this evidence,
Yes.
you
Yes.
hand over to
Yes, my lord.
court master. Okay, heard
And-
Mr.
LCR
P.K. Deka.
LCR
Elcher is here?
Yeah.
Okay, then all right. Mr. P.K. Deka, learned counsel for the appellant, and Mr. S.K. Ghosh, learned counsel for the respondent. Argument concluded, order is at.
March.
Next, on 22nd August.
22nd. Heard Mr. B.J. Mukherjee, learned counsel for the appellant, and Mr. A.T. Sarkar, learned counsel for the respondent. On the pair being made by Mr. Mukherjee, learned counsel for the appellant, Justice shall list the matter on
22nd August.
22nd August.
Timing item, timing item number 3.
Yes.
Lordship.
On the other day, I have asked you to produce some judgments in respect of
Yes, ma'am.
this extending the benefit of section 3 and 4 of the provision of the Offenders Act.
My lord, I have also submitted some other judgments. regarding this aspect. First one is, my lord, our High Court decision regarding acquittal, my lord. And second, in respect of plea of probation of offender act, 1950.
Which paragraph of the first judgment you have relied upon?
My lord, this is for acquittal, my lord. First one is our High Court.
Ah, yes.
Yes, my lord. Paragraph, my lord, I mentioned here 17, 18, 20, 21, 24, and 25, 26. Some,
17, 18,
yes, my 20, 21, 23, 24, 25, and 26. ma'am. Short judgment.
21, 24.
Yes, ma'am. I have mentioned in first one.
Acha.
Relevant parameter.
Hmm. So in respect of acquittal,
My lord.
that was not the issue before this court.
But I argued my lord in this case because my lord, the doctor, my lord, who examined, he's saying that it is simple injury, my lord. And
Pardon?
Simple injury. The doctor report stated it's a injury is simple, my lord.
Hmm.
And there is some discrepancy in the my lord, medical report
Hmm.
because there is no dimension has been given, my lord. Only so much centimeters.
Hmm.
How much depth is also not there, my lord.
Hmm.
And my doctor says, my lord, it may be from fall off.
No, but that suggestion was not there in the cross-examination.
It is there.
That she sustained the injuries by falling on
Right.
sharp object.
And second issue was, my lord, from the FIR, my lord. FIR is something different, my lord. I should, my lord.
No,
Some
there is clear finding about that the nature of injury is grievous. Right.
It is there. And my lord,
Yeah, there was fracture also perhaps.
no, my lord. Simple. In medical report, nature of injury is simple.
Then how can the trial court consider it as grievous?
Because my lord, from the evidence of the
Yes. If there is discrepancy between medical evidence and ocular evidence will prevail, not the medical evidence.
Yes, ma'am.
That is the settled proposition of law.
It is there, ma'am.
Hmm.
But there is a, my lord, contradiction in their statement.
Contradiction?
In their statement, my lord.
Hmm.
PW1, my lord, she's the victim, my lord. Her version is something different, that of her girl, my lord. And girl,
That of her?
Girl, daughter, my lord.
Maybe.
And boy, her.
The evidence of the injured witness
Yes, ma'am.
is in higher pedestal than the other witnesses.
But my lord, the weapons which was seized after 4 days, my
Hmm?
lord. 4 days, my lord. The X. It was seized after 4 days.
Maybe. How it would affect the veracity of the prosecution evidence?
Well, this is not seized in presence of the my lord, appellant, as well as it is not sent to the forensic also.
No, even in the case of non-recovery of the weapon of offense also, it has no bearing upon the veracity of the prosecution person. Right? Yes, sir. Regarding alternative sentence,
My lord, regarding my lord, this is in Probation Act, my lord, I have cited some judgment, my lord. Where it is stated that, my lord, I found, my lord, in case even in 307, my lord, what
page number?
Lordship will find second judgment, my lord.
Second judgment, yes.
Yes, my lord. It's Lordship 10, 11, 14, and 15, my lord.
Ten, 11, 15, and
10, 11, 14 and 15. But there is a discussion in this manner. Section 3 and section 4 manner. Second one, judgment manner is related in this judgment manner. That's why. Same finding manner.
So in that case, the age of the accused were 19 and 21 years.
Not what I understood, my lord, section 4, my lord, it says, my lord, even, my lord, not under age, it also include, my lord, upper age also. And, my lord, in my case, my lord, conviction 5 years. It's not life or, my lord. So,
But the section provides.
section 4, my lord, it provides, my lord. May I read, my lord? Power of court to release certain offenders on probation of good conduct. When any person is found guilty of having committed an offense not punishable with death or imprisonment for life, and the court by which the person is found guilty is of opinion that, having regard to the circumstances of the case, including the nature of the offense and the character of the offender, it is expedient to release him on probation of good conduct, then not notwithstanding anything contained in any other law for time being in force. The court may, instead of sentencing him at once at any punishment, direct that he may be released on his entering into a bond, with or without sureties, to appear and receive sentence when called upon during the such period, not exceeding 3 years, as the court may direct, and in the meantime to keep peace and be of good behavior. Provided that the court shall not direct such release of an offender unless it is satisfied that the offender or his surety, if any, has a fixed place of abode or regular occupation in the place over which the court exercise jurisdiction, or in which the offender is likely to live during the period for which he enters into the bond. Before making any order under subsection 1, the court
So, you see the section 307,
Yes.
punishment is liable if hurt is caused to any person by such act, the offender shall be liable either to
Yes, madam.
imprisonment for life or to such punishment as is herein before mentioned.
Yes.
So life imprisonment is there if
No,
the hurt
and-
is caused.
What I meant, what section 4 says, my lord, that is, when any person is found guilty of having convicted an offense not punishable with death or imprisonment for life.
Here,
So-
life imprisonment is provided, 307.
No, here in my case, my lord, 5 years convicted. 5
No,
years.
the court has imposed 5 years, but the punishment prescribed is life imprisonment if hurt is caused.
Lordship.
So whether this provision can be invoked, section 4 of the provision of the offender.
What I understood, my lord, subject to lordship correction, my lord,
Mm.
in this Supreme Court judgment, my lord, this was, my lord.
Which one?
First, my lord, second one, my
Ah.
lord. In this case, my lord,
That-
it was
that-
section 397.
Ah.
397.
It was punishment, my lord. 397, robbery, dokaiti with attempt to cause death or grievous hurt. If at the time of committing robbery or dokaiti, the offender use any deadly weapons or cause any so and so manner, punishment, rigorous imprisonment for not less than 7 years, cognizable. This is their one. It is not less than 7 years. But my lord, what I understood, my lord, if he is convicted life or then only my lord. bar will-
No, section provides.
Yes, ma'am.
Section provides. Court chooses to impose only 5 years
Yes, yes.
instead of.
One judgment I
Uh,
have annexed, my lord, is the Rajasthan High Court, my lord. That's in the policy. One judgment, my lord. I have annexed.
Which one?
It's my lord, High Court of the Rajasthan, my lord. Lordship will serially 3. My lord, in this case, my lord, after citing all my lord, citation, which was the case of 307, extended the benefit of section 4, my lord.
Their charge was under section 34, read with section 307.
Yes, my lord, but his conviction was, my lord, under section 307 also. There is a discussion also, my lord, 307.
But Rajasthan High Court may allow it, but the question is
But, here also discuss about the section 4 of the Probation Act, my lord, and some judgment on.
yes, any other judgment?
No, another, my lord, I have for the alternation of, my lord, last one, my lord. My lord, this was a case, my lord, which is convicted under 307, my lord. But my lord, subsequently here found not repeated, my lord. They have found, my lord, some not repeated though, and accordingly it was, my lord, altered to the section, my lord, 324. Modified to under section 323 and 324 of the IPC. There are 9, 10 and 11.
There are
9, 10 and 11.
Yes, Mr. Lockhart.
So here, the in main case lordship, the section 4 of Probation Offenders Act, they are claiming lordship. But the section itself says lordship. What it says lordship? When any person is found guilty of having committed an offense not punishable with death or imprisonment for life, not punishable lordship. When the what itself says lordship, that the section, what is the punishment of that section? But the code has after code has given, that is not the meaning of this section lordship. Otherwise it would be written as punished.
What is provided in the section itself.
it would be written as a punished, but it is not punishable. It is written as punishable. So Lordship, section 4 from the very first line, Lordship, section 4 is not may not be extended to this person, Lordship. And apart from that, Lordship, there is his conduct, Lordship, for giving. Apart from this also, Lordship, for getting that Probation of Offenders Act, his conduct should be good, Lordship. When there is a statement from the petition victim, Lordship, that earlier there was a case, Lordship, against him, Lordship, and for informant, so it says, Lordship, there was also a step, Lordship, stomach on stomach, Lordship. He used to do a step. So, Lordship, his conduct is not good, Lordship, and when his own daughter giving witness against him, Lordship, and in that case, Lordship, two eyewitnesses are there, Lordship. One independent witness, Lordship, who she is also she has also witness against him, Lordship. And for attracting 307, Lordship, it is a common law, Lordship. For attracting 307, there may not be any grievous offense, Lordship. 307 does not do not require any grievous offense.
Who was the independent witness? One is son.
Yes,
One is
son,
daughter.
PW3.
And the independent witness is
Lordship,
One, my lord, neighbor.
neighbor.
Lordship.
Yes.
What was his name?
That is a PW4, Lordship.
Hmm.
My lord,
PW4, Lordship.
PW4.
May I read her statement, Lordship? Okay.
Huh.
I know the accused.
Oh, what is the name?
PW4.
Her name is, Lordship.
No.
My name is Sahadat Ali.
Sahadat Ali.
His name, Lordship. His statement is like this, Lordship. I know that
PW4.
PW4, Lordship.
Hmm.
I know the accused Sarajuddin and his wife, whose house is near my house. I do not know the informant. I do not know the informant on Iman 30/10/2020 at about 6:30 to 7 p.m. while I was going to the river bank through the road. At that time, I heard Halla in the house of the accused, and I saw the accused Sarajuddin was running, and at the back to him, his son Miraz Ali was also running, and I caught Miraz Ali as I thought why he was chasing his father. The accused Sirajuddin. At that time, I asked Miraz Ali why he was chasing his father, and he stated to me that his father assaulted his mother. After some time, I saw his mother who came out of his house, and I saw blood was oozing out from her head, neck, and she was stained with blood on the whole body. So, Lordship, this is the when she is also stated like same witness, Lordship. And Lordship, apart from that, Lordship, the injuries, Lordship. But the mother has stated that where he has got injuries, Lordship, forehead, and arm. And all the witnesses has stated the same thing, Lordship. And when there is a injury on the vital part, Lordship, it amounts to attempt to murder, Lordship. It is an attempt to murder because it is a vital part. And attacking, assaulting with an axe, Lordship. Attempt to murder will definitely come, Lordship. So, Lordship, at this stage, Lordship, the Probation of Offenders Act, the section itself says, Lordship, that as the section is when the section 307 is punishable with life imprisonment also, so that section does not attract, Lordship.
But in the last judgment he has referred to, it is stated.
It is. Today, just now, he has supplied a copy to me also.
No, in the last judgment, it was altered to section 323 and 324.
Yes, my lord.
But in the judgment of Rajasthan High Court, he has referred to this probation benefit of the section 4 is extended. In the case of 307 IPC also. So let us do one thing. In the meantime, he furnish a copy to you. You go through it. You apprise this court on next date. Okay, when can it be fixed? Friday?
Hearing matter.
On
No, maybe
Thursday,
hearing matter on Friday can it be fixed?
Thursday can be, if possible, Thursday.
Thursday? Thursday, a lot of matters are there. হ'ব এইটো কৰিলে আমাৰ থাকি গ'ল থাকি গ'ল Friday?
Friday.
Friday, actually, I may not be available.
Huh?
Friday, I have some other
Then
programs, so that is why.
when? Thursday?
Thursday,
Okay, then Thursday we'll try. Heard Mr. Uddin, Learned Counsel for the appellant, Mr. Locker, Learned Additional PP for the respondent number one or two.
That's it. For him,
You are for two. Then Mr. S.A. Ahmed, Learned Counsel for the respondent number two. Heard in part, unleash the matter on Thursday. Yes.
Timing item 16.
May I please, your lordship?
Yes.
Little technical problem has come up, my lord. What happened? This here learned friend P. Sharma and Subhash Sharma is appearing all along. On behalf of respondent number. Now, Mr. Sharma has told the last occasion that the brief is taken by respondent number. But accordingly, last date was order also passed to, so that respondent can engage the council. Now my learned friend is appearing on behalf of respondent, sole respondent.
Lord-
That is why,
Lordship, in the year 2022 itself, the respondent took the brief from us and we intimated court for honorable court beforehand also. And since the last 2 dates, when the case was listed, we were not appearing.
no, that was here. That is why,
Oh, why the case was earlier listed before a DB?
because earlier matter was taken by DB. Now only because as per notification, it has, I have come to know. This it is now, because
No,
Jorhat.
no, why you have to take fresh system because earlier council
I have
appeared.
actually, see, one way thing, that is your lordship. Of course, lordship is also one by one, there's rightly, because she has already appeared.
Yes.
She knows that lordship may take also this matter by this way, not only my submission, because honestly, I'm submitting an entire facts before lordship, because there should not be any technical problem in future. There is but this lordship is correctly saying, because after receiving notice, she has engaged counsel. She has knowledge, and it is also have knowledge that she has taken the brief.
Okay, let us do one thing. Reste will issue notice to the respondent. Thereafter we will say.
This is.
Lordship, my statement at least can be recorded, Lordship. My statement.
Yes, I will record your
withdrawn
statement.
our wakalat.
But
Heard Mr. C.
only,
Borua?
my lord, because it is a long time, it is
Yes, we'll fix a very short day.
14 years, 10 years ago,
Hmm.
10 years separation.
No,
More than-
we can dispose it of, but
Yes,
in
my-
future it may
That
be
is
a
why I
problem.
have seen, because similar situation one has happened
Mm.
when my earlier joining 30, because one lead this happened, because this brief is taken not according to ultimately we lost the case. Good case been lost by us, by other party and their appeal. That is why also be clear, my lord.
Heard Mr. C. Borua, Learned Counsel for the appellant, and also heard Mr.
S. Sharma.
S. Sharma, Learned Counsel for the respondent.
Who
Mr. Sharma submits that the respondent had already taken back the brief from him. When?
in the year 2022, Lordship.
In the year 2022, and since then he has no connection with the respondent. In Viva Vaibhav, it is provided that Reste shall issue notice to the respondent by registered post and also by usual process within a week from today, returnable after 4 weeks. 4 weeks.
Lordship may reduce my 7 days may reduce. I'll take by 2 days. Tomorrow itself I'll take. That is why, so that listing can be little earlier after 3 weeks. That may be fixed.
Date.
Or
Okay,
the
okay.
date will be difficult, I think, no? After 3 weeks, my lord.
3 weeks.
3 weeks.
Okay, 3
I'll
weeks.
check with it. Your lordship may reduce my timing, 7 days.
Okay,
It may go
okay.
to 3
1
days.
week.
3 days.
Within 1 week. Within 4 working days then.
Fine.
4.
And 3 weeks after 3
Okay.
weeks. Highly obliged, my lord. Because I wanted to do it. That's it. 2 times I took your lordship time.
Yes, yes.
But now I have seen this is a may come up for everything. We should be clear. And it is also learned that respondent has become counsel also. Lawyer also. There will be very, very perfect and courteous. Highly obliged, my lord. Sorry for this one troubling, my lord.
No, no, no.
2 times I took time this morning.
Any matter? No, what?